In this video, I want to take a look at powers of attorney and in particular the enduring power of attorney, how to create and register an enduring power of attorney. Firstly, the relevant act is the Power of Attorneys Act 1996, and an enduring power of attorney is an instrument or document which creates a power. It contains a statement by the donor to the effect that the donor intends the power to be effective during any subsequent mental incapacity of the donor and complies with the provisions of this section and regulations made thereunder. Essentially what we're talking about here is a person who knows full well what they're doing, there's no difficulty with their mental capacity or anything of that nature, and they create an enduring power of attorney for the day if it occurs that they no longer have the mental capacity to make decisions for themselves. It is possible that you would make an enduring power of attorney and it would never be relied upon or never invoked or used because the person simply never loses mental capacity and perhaps passes away or something of that nature. As I say, an enduring power of attorney can be created. It could last for 20 years and it may never be used. However, it is very, very useful if it is called into action. So an enduring power of attorney comes into being when a person becomes incapacitated, and that's incapacitated in terms of making decisions for themselves and so on. It allows the donee, that's the attorney, to make personal care decisions on behalf of the donor when the donor becomes mentally incapacitated. So the element of or the extent of the powers that's granted by the enduring power of attorney is a matter for the donor to consider at the outset. Who can be an attorney, however? Anyone generally can be appointed an attorney. There are exceptions, for example, a bankrupt or a person under 18 years. Creating an enduring power of attorney is more complex than creating a general power of attorney. A general power of attorney is a situation where I've dealt with it many times myself, where somebody from Ireland, for example, is living and working abroad, and they give me a power of attorney to sign contracts for them and perhaps sign other documents in the purchase or sale of a property. It's just convenient. But that specific or that power, that general power, would be only for the purpose perhaps of the conveyance. So that's slightly different from, that's a general power of attorney. That's a fairly straightforward form that can be executed. This enduring power of attorney is different, it's more complex because you'll need a doctor and you need a solicitor. So the instrument or document, it must include a statement from the doctor that the donor had the mental capacity to sign it at the time it was signed and understood the effect. In other words, the donor must understand what it is he's doing. It must contain a statement from the donor to the effect that he knew the consequences of creating the enduring power of attorney. And it must include a statement from a solicitor that the donor had the capacity to make the enduring power of attorney and that the donor was not acting under any duress or undue influence. There's a notification procedure then required. At least two people must be notified of the making of the enduring power of attorney, and these two people cannot include the donee. So two other people, apart from the attorneys or donees, must be notified. One of the notice parties must be a spouse or civil partner. If there's none, a child must be notified. If there's no child, then a relative must be notified. There is a hierarchy of people who must be notified. It's not a question of just notifying two neighbours or two random strangers. There must be somebody who is related to the person, the donor. Registration then of the enduring power of attorney only comes in or only arises if the person loses capacity and loses mental capacity, and the enduring power of attorney then is going to be relied upon in order to make decisions by the attorneys, by the donees, on behalf of and for the benefit of the donor. It only comes into force when it's registered, and this involves an application to the Registrar of the Wards of Court in the High Court, and this can only be made when the donor is or is becoming mentally incapable. There must be a medical certificate confirming that the donor is incapable of managing his or her affairs. The High Court then has extensive supervisory powers in respect of the EPA once it is registered. It can give directions about the management and disposal of the property of the donor, and it can revoke or cancel the EPA if it is satisfied that the donor is mentally capable, fraud or undue pressure was used in the creation of the EPA, or the attorney is unsuitable. The powers of an enduring power of attorney. An enduring power of attorney can give general powers, including personal care decisions, to the attorney, or it can give specific powers. So there could be specific powers granted only, for example, in relation to personal care decisions. All decisions must be taken in the best interest of the donor, and the donor's family and carers must be consulted. Personal care decisions include things like where the donor should live, their dress and diet, who they should see and not see, and so forth. These are actually set out in the legislation in the Powers of Attorney Act 1996. A donor can revoke an EPA anytime before it's registered. However, if it's registered, an application must be made to the court to have it revoked. An EPA ceases on the death of the donor, and there are also some other limited circumstances where the EPA will be terminated. My name is Gorry. I'm a solicitor in Enfield. I hope you find this video useful. If you do, you might give it a thumbs up down below, and you may be interested in subscribing to my YouTube channel. And remember, when you subscribe to my channel, the only way we won't be connected in future is if one of us pops our clogs.